A very good morning. Not knowing the law is not an excuse. So the Law and Order program, where we discuss the legal problems and giving answers for the prominent questions, has taken a prominent place in television programs. And today also we are going to discuss one of the most important areas when it comes to property. And to do the honors with us, we do have Senior Counsel Attorney at Law, Mr. Ian Fernando. So thank you very much, sir, for joining with us in this program. And basically, when moving to the law of property, it's a wide area. And as a practitioner with more than 3 decades, you might have certain experiences with dealing with numerous types of cases. So simply, when it comes to the ordinary context, people suffer when buying lands. What I mean suffer is that if they invest money on a wrong place for a fraud or whatever it is, they are in trouble. So when buying a land, what are the most important things that they need to check?
When you are buying a land, it's best that you see it physically and check on the metes and boundaries of that land, and also collect the plans and deeds from the owner, which are at least 50 years backwards if you can.
50.
Otherwise, at least 35 years. I will enumerate that later.
Right.
And do a search in the land registry to see whether there is any encumbrance on the land.
Right.
That is, whether there is a caveat or where there is a lispendence obtained on the land. For examples, if you come across a situation where you are going to buy a land and that land was subject to a life interest of some person and that person is not dead, then you need to have that person to sign the deed to relinquish the life interest.
Right.
Similarly, if you have a land which is undivided half share and that undivided half share has been disposed by A to B, who was a minor, and C has taken over that land to be the donee, to accept the deed on behalf of the underage girl, then that type of matter should be considered very carefully, because there may be an action that is pending on a lispendence, or there may be a caveat which will, the new buyer who is going to buy the land, if he buys with a caveat, he will have an issue. The word caveat means buyer be aware. Like we have on the notice on certain gates, beware of dogs. In the similar situation, buyer be aware that someone else is claiming the title, that is the ownership, that's called right, title and interest on the particular land.
Right. So we have to be aware about caveats, lispendence and certain boundaries. We have to check it, and we have to do a small research part on that, and with proper guidance and consultations we can sort out that issue. So simply, when buying a land, most people they can pay money to the land, but they're reluctant to pay the stamp duty.
Yes.
What sort of undervaluing is there?
There are 2 types that the alienation of property can take place. One is transfer, one is by deed of gift.
Right.
If it's transfer, for the first 100,000 you need to pay 4%, 3%. Thereafter, for every 100,000 you need to pay 4%. That's a stamp duty value. If it's a deed of gift, it's the other way around. For the first 50,000 you need to pay only 3%. And thereafter, for every 100,000 you need to pay 2%.
Right.
Now, the duty upon the person who is writing the deed is to check the title. Also, there is some part of a duty on that notary to see that the correct valuation goes in.
Right.
So that has been now taken away from the hands of the notary, because we have now in Colombo a Western Provincial Board which decides the value of the land.
Right.
So if you get a certificate from the valuation board that the land is valued at this particular amount, you can put that particular amount on the deed.
Right.
However, if you otherwise undervalue and get caught, you might be in serious trouble, because you will be called before that board for your undervaluation, and it might hamper the deed being registered.
Right.
And you will have to pay the balance, maybe as a fine as well.
Right.
So it is far better to go to the valuation board of that particular area, especially Colombo we have one, get the valuation, and upon that valuation write the deed. Because if you want to undervalue the land that you are having, not only the valuation board, you can get a valuer's report undervaluing the land for reasons.
Right.
That is, it's flooding, there is a misconception regarding the boundaries, or there are so many reasons that the land can be undervalued at, and get a valuation report, and the notary can upon that valuation report write the deed. But the issue is, when you go to the bank to mortgage that property, to get a bank loan, the bank loan will only be got at 75% of that reduced rate that you have written the deed. However, if you are given a valuation more and a little above the normal valuation, you can also get 75% on that mortgage, which is much more worth to you than undervaluing the land.
Right.
The cost of the valuation report might sometimes be so great that it might be not worth undervaluing the land.
Right. So even to undervalue, there should be a reason. Right. So then simply, sir, you said about deed of transfer, deed of gift. For an example, simply, if I'm going to buy a land from someone else which is not known, deed of transfer, that is the way. So suppose that I'm going to give my property to my son or daughter. Some people try to do that through a deed of gift.
Yes.
So what is the difference?
The deed of gift is where you can put the 1978 value, wherein you can undervalue to the extent that is allowed in that act, that 1978, which will give you between your father and son, between your family, what transpires, you can put it to that valuation. But you cannot undervalue if you are not having some very close relationship with the other party. If it's a family concern, certainly you are allowed to undervalue. There is no question about it. Right. But if you are having some other friendship or relationship, that might be a questionable point when you write a deed of gift to a party, because no consideration or no money has passed from one person to another.
Right. So that is the deed of gift and the contradiction with deed of transfer. So anyways, for a deed of gift also, we have to pay a considerable stamp duty.
Correct.
So to avoid paying such stamp duty, some people try to insert it to the last will of that particular person, and once after the demise to obtain that property. How that?
That's a very dangerous situation, Charit. Because once you write a last will, until your last, you can keep changing your last will.
Right.
So there is no finality that that person can think, oh yes, I have been given the last will and this property is coming to me. So many families, their children look after their parents in their yesteryear, in the evening of their life, contemplating that their properties will be written to them in their last will. But when the last will is opened after the demise of the deceased, they find that the last will constitutes something totally different.
Else.
It has been written to someone else. So it is very dangerous to have a situation where in your last will you are bequeathing property to another party. The party concerned, if he is interested in getting his ancestral property, should go in for a deed of gift. And it will be much safer in a scenario like that, that the person who is giving the deed of gift writes the deed of gift with life interest. I have seen several deeds of gifts being revoked by the parents due to their children not looking after them, or doing certain acts which are detrimental to them, not looking after the older parents financially and medically. And in fact, we have the Elders Act now in force for such children who don't look after their parents to be brought into court and orders to be made for them to look after. So there are grounds on cruelty on which that deed of gift can be set aside. We had a particular judgment recently, the Supreme Court, where I said that the deed of gift can be revoked by annulling that particular deed of gift by just another deed. But subsequently that law has now changed. So you have got to go to court and prove that the person you have gifted the property to has done acts of cruelty, not one single act. So many acts of not looking after you, not giving your medication as an old person, so many acts to be done. And only in those circumstances that court will go through all that and negate the deed of gift.
So suppose that say the last will, I'm giving my property to my son, it's 100% sure. So once after my demise, so how my child or daughter, whatever, how can he or she get that property written? Because a dead person can't write a property.
So we have the testament case where you have to put the last will to be proved, where in a last will the notary and 2 witnesses must sign, or at least you must have a last will where 5 witnesses must sign at one at the same time.
Right.
That is very important that they sign one at the same time, because if they have not signed at one at the same time, according to section 33, I think, of the notary's ordinance, that particular document will not be taken into force. And section, I think, 7 of the Prevention of Frauds ordinance also sets out the situation that if the document is not signed at one at the same time and there is an issue regarding the particular will, you will have to go through the court procedure to prove it. If you are unable to prove that that is signed at one at the same time, you will fail in your case and your last will not be proved.
Right. So suppose that a person has died intestate without writing his property to anyone else, how that the property is being divided?
So if he is a person who has died with a family, we say family of 2 children, his property half goes to his wife, the other half goes to the 2 children. That is, each person will get quarter. So there will be 2 quarters for the 2 children, which constitutes the half, and the other half will go to the wife. But if it's a scenario where he has died and he has no children, then half goes to his wife and the other half goes to his parents.
Right.
And in the scenario his parents are not living, the other half goes to his brothers and sisters in equal shares. So we take a situation where a person has died, he has no children, 50% of the property goes to his wife, the other 50% goes to his parents. If the parents are not living, that 50% goes to his brother and sister, 25-25.
Right. So when it comes to a certain scenario that a person has died, half goes to his wife and half goes to his children. So one child is married, but the child is died, so his wife is there. So will that half allocated to that his wife?
If I get you correct, you said that the person who is deceased has one child.
One child.
And the child is dead. And so long as the child is dead, that half share goes to his wife.
Right.
If there is no children, 50% of that first goes to his wife of the deceased. Since his son is dead, the other 50% goes to his wife, that is to her. If she has children, then it will get split to the children as well.
Right. So most important areas with regard to property. And one thing that I want to emphasize in this program, and most of the viewers are expecting, there's a word called court commission. So what is it, sir?
When you can take a court commission is where you come into a situation where you can't define the land and you can't check on the metes and boundaries before going to court, and you have to go with proper metes and boundaries to court to file a declaration action or action to eject someone or to repossess your property. So you need to have a court commission issued through court, setting out the procedure that you need a surveyor, which will be naturally given by the court panel, to survey your land and ascertain the exact situation of your land, because the land boundaries can change due to so many things. There can be the fences which I come across, there could have been new walls that would have come across, so there can be so many different areas in which the land boundaries will change. So to stop that and to be very certain on what you are going to ask from court, which area of the land, there will be a court commission issued, and you have to file papers under section 428 asking for the court to allow a surveyor to survey the land and give a report on title, also the report on the surveyor to the courthouse to be led in evidence to prove the dimensions of your land.
Right. So that is court commission. And when it comes to ownership, can you just elaborate on that ownership?
Ownership, basically, Pollock has described the jurisprudence, one of the best people in prudence, that 9/10 of possession of a land is ownership.
Right.
However, ownership can be got through different means. One is by title, where you get by deed. One is by prescription, where you have prescribed to the land being 10 years in occupation and the owner has not come and done an overt act Overtax means go to the police station and make a police entry to get you out of the land, or to come with some thugs and tell you to move out of the land, or come and pluck your coconuts inside your land, has not done any overtax. Then if you are in undisturbed and uninterrupted position for 10 years, you can own the land, and you may write a deed of declaration that you have been in possession for such a long time, and therefore you are the owner of the land. That will also amount to you having your vote from that particular place, may be a successful point for you to write a deed of declaration that you have been there for 10 years without the owner asking for the land.
Right. That means it has the same validity, deed of declaration, as
deed of declaration has a validity, but sometimes it can be tested in court how genuine you were when you were writing a deed of declaration.
Right. So you talked about ownership, and then it comes to possession. What is the difference between ownership and possession?
As I said, Pollock said that 9/10 of possession is ownership, but in ownership there are certain attributes that you should have. You should have the attribute where you can sell the land. You should have the attribute where you can earn from the land, from the produce, right? And you must be in full control of the land. Those are some of the aspects set out in our law books as to show you how you get ownership. Now, for example, possession, you can't sell your land, so you are not having the ownership right.
Right.
You may be able to get the benefit of the fruits of the land, right? But still you don't come to the question of ownership where you are allowed to alienate the land or do anything with the land. Right. So that is the difference between the possession word and the ownership word.
Right. So when it comes to a land, each and every person who owns a land must have access to that particular land. So can you just little bit comment on that?
You take the situation where there is a roadway to the land, and in that roadway, if you are having soil rights, you are sitting very pretty on your property, because you have a good right of way to your land. But if you have a servitude right, the servitude right is the right of usage of the road, which is given to you by deed. You might have issues in coming up and down your land, because there may be several cars parked there on the land, which you can't get them to move out their cars because you don't have the ownership. The ownership might be with another party who has parked the car, and he has a right to park the car. However, if you have a servitude right, a servitude right means you are going up and down the road, you have a right to use the road but not ownership, and the other party also has a servitude right to use the road, not the ownership. He can't stop you from any obstruction. Right. He can stop you only, he can't get an injunction against you. He can't go and park a car there and say that he owns the road. You can't injunct him by using for these acts, because you also have a servitude right. So you might file a court case and come into a conclusion, okay, he can park the car only at these hours, I can park the car only at these hours, or no one can park the car, and all must be allowed to go through the roadway.
Right. In some cases that we have said that this is a private road, parking is prohibited. Correct. That comes to the same context. Correct. Right. So when it comes to that access that is belonging to a certain road, but suppose that I do have a land, but somehow I have no any particular access. So can I use some other's property to access that land?
If you have a right of servitude over that land, for example, if you have been walking through that land to the next road on several times, or if you have been drawing your cattle over that particular land, or if you have been taking water over that land, and you have created with you a servitude right to walk over that person's land for over 10 years that you have that servitude right, then you can argue that you have a right to go over another's land.
But that is not my property.
Although it's not your property, for the last 10 years or a long period of time, if there has been the villagers or the people using that as a shortcut over that person's land, they are entitled to use that roadway.
Right. Is it a branch of like prescription?
I would put it this way, it is not exactly prescription, but it's a servitude right.
Right.
The dominant tenement is the land, and the servitude right is where you are entitled to use that roadway because there has been a user for a long period of time. But non-user of that land, that your servitude right got wiped off, is a very difficult task to prove in court.
Right, exactly. So when it comes to that property, we have many interesting things to discuss, and as we are coming to the latter part of the program, one thing I want to enlighten is that a small question, sir. Suppose that my property has some rainwater dropping from some other one's roof or adjacent property or any building, what is the legal perspective?
The legal perspective is that you can stop the rainwater that is going from your land to another land. Otherwise, that famous principle of Rylance versus Fletcher will be also utilized, wherein you are supposed to divert the water away from your land. But if it's from a situation where you have a higher land coming to a lower land, and the rainwater has been passing through for a considerable period of time, prescriptive period of time over 10 years, you can send your rainwater through that particular land. There are a lot of issues that come up, and the municipality is called upon to be a party in those cases, wherein the municipality will decide a best way of setting the rainwater out, and that is the solution to the problem when it comes to a court case. But we see numerous amount of court cases filed because the neighbor's rainwater is flowing through your land.
Right.
In the same way, the eaves of your building, if it's protruding into the next person's building, that person has a legal case against you to stop that rainwater falling from the eaves of that neighbor onto your land.
Right.
He can go in for a court injunction and get that done.
Right. So only rainwater, or what about the trees falling, like
Yes.
protruding?
If you're having overhanging branches on your property from the other person's land, and if it's a good mango tree and the mango tree is bearing, you are entitled to pluck those fruits.
Right.
You are legally entitled.
Uh-huh.
Also, you are legally entitled to that if you don't like that mango tree, overhanging branches on your land, you are entitled to cut the branches so long as it's protruding only into your land.
No need to inquire permission from them.
You don't have to get any permission.
Right.
In the same scenario, you have a servitude right. Of course, that's not a servitude right I spoke to you early on about the mangoes. You have a servitude right when you are painting your building. If you are having a blind wall, where you can come and put your scaffolding on the neighbor's land and climb up and build your and paint your land. Right. That particular case law is set out somewhere in 75 NLR. I couldn't get the reference for you,
right,
but it clearly says that you have a right to go onto the next door neighbor's land and paint your building.
Right.
It's a blank wall.
Blank wall, right. Most of the interesting pieces of law of property we discussed in today's episode, and we emphasized on certain case laws which were discussed in courts, and giving prominence to that area, we elaborated our facts. Thank you very much, sir, for joining with us with today's program, Law and Order. And we had an interesting discussion about law of property, and we are going to have one more discussion because the law of property is a wide area. And thank you very much for doing us the honors, Mr. Ian Fernando, Senior Counsel and Attorney at Law. So, ladies and gentlemen, the Law and Order program providing you the most suitable answers and the legal knowledge that you can survive in this time period. We are looking forward to give you more topics, more discussions and more knowledge on law, because not knowing the law is not an excuse. Thank you very much for watching. Have a pleasant day.